You are listening to the Justice in Heels podcast with me, your host, Daniélle Hayward. Join me as I discuss interesting legal topics with inspiring female legal professionals who paved the way for the rest of us. You are listening to another episode of the Justice in Heels podcast. Today I have Jo Eksteen with me. Hi, Jo. Welcome to the podcast.
Hi, Daniélle. Thank you for having me.
So can you tell our listeners in a nutshell, who are you?
Well, I don't know if I can describe myself in a nutshell, but
your best.
yeah. I served my articles for 5 years at Venter & Von Abo Attorneys. And I extended my right of appearance for 6 months. I often say I think I've served longer articles than anyone before me. I obtained my LLB degree from UNISA in 2020, and I was admitted as an attorney in August last year, and I immediately was appointed as a director at my firm.
That's fantastic. So today we are speaking about child court matters and more specifically parenting plans and maintenance. So can you firstly tell us, Jo, what is a parenting plan and who can draft a parenting plan?
Okay, so a parenting plan is a document that regulates the care and contact between parents and their children. And this is a document that is usually drafted after the separation of the parents and upon divorce of parents. Not all parents are married. Some children are born outside the bonds of marriage, and both parents' rights and responsibilities with regards to these children, whether married or not, are recognized. It regulates, in short, with whom the child will live, who will be the primary caregiver of the child. It will sometimes include maintenance, not always, but most of the time maintenance will be an aspect of discussion. And the most important thing is that it regulates contact between the child and the parent who is not the primary caregiver, who is usually the parent that will have rights and contact rights on a rotational basis with the parent with whom the child stays.
Very interesting.
I don't know if that answers your question.
Yes, it does.
Yeah.
So I think it's also necessary to mention that there are many things in law, and more specifically family law, where the parents or the parties may not need an attorney. But it is important to note that a parenting plan needs to be drafted by an attorney. Am I correct in saying that?
Yes. Yes,
Okay.
not always an attorney. He looks somewhat in the shoes of or in the role as a social worker. The family advocate is also known for compiling parenting plans. They will usually make a parenting plan or draft a parenting plan in instances where the parents are having a dispute as to where the child must live or when each parent will have contact. Then usually it is necessary for a third party to intervene in the form of the family advocate. But yeah, usually it happens between the parents. The parents necessarily indicate what they want contained in the parenting plan, and it is then dealt with by a third party who is a person who has knowledge about drafting parenting plans, attorneys, social workers, and then the family advocate is also an option. Yeah, but it must always be drafted by a professional person because the moment it is signed and entered into, it becomes an agreement. So then the parties are bound by it.
Lovely, very interesting. So, on the topic of maintenance, what are some of the biggest misconceptions that people have about child maintenance in South Africa, in your opinion?
Well, there's a number of things now The first and most prevalent thing is many people believe that maintenance is a voluntary thing. It's not a voluntary thing, because as a parent has rights, they also have responsibilities. So they have each parent and every parent has the responsibility to maintain their child. Law of Person says we also have a responsibility to maintain our parents should they be in need of maintenance at some stage. But yeah, this is something that is regulated in terms of law of persons. We have a right, we have a responsibility towards our children to maintain them. Right, none of them asked to be here. So the other thing is that many people believe, and I'm not going to go into detail, but many people believe that once a child turns 18, you can just merely stop maintaining them. People must be very careful with this, because the moment there's a court order that says you must pay maintenance towards a child, you have to apply to the court to set that order aside, to discharge your maintenance obligation. Once the child turns 18, you cannot merely stop paying maintenance. That's the second thing. Another thing is that many parents, especially in extremely volatile divorces, would say that, no, I don't want the father or mother to maintain the child, I'll deal with it myself. Many people must people in general must just keep in mind that maintenance is a right of the child, not the parent. No parent can say, but I don't want maintenance for my child. It's not your right, it's your child's right. So the child has the right to maintenance, not the mother or father. So you cannot do away with maintenance for a child. There must be some sort of agreement. It's often in our divorce courts where people would say, no, I'm going to refer the maintenance to the relevant court, the relevant maintenance court after divorce, and that's just simply not correct anymore, because it's not, these things must be dealt with as they poke out their little heads. So whenever there's a case where there's a need to discuss maintenance, especially in a divorce, deal with it, because it's the child's right. It's not the parent or client's right, it's the child's right. And what does the Children's Act tell us? We must always protect the children's right. It must always be paramount.
Everything that involves the child must be in the best interest of the child. Lovely. Thank you for sharing that.
Yes.
I think a lot of our listeners will really take this advice to heart. So let's say we have someone listening who cannot afford to get an attorney to assist them with claiming maintenance. How can they run this process themselves?
Well, you attend to the relevant maintenance court. There's a form that you need to complete. In terms of the Act, I'm not going to be very specific because it helps no layperson to quote sections of the Act. But there's a form. Application form where you apply to get a maintenance order against someone else. And then there's a list of documents that I always give my clients that you will need before you compile that document, or before you start completing the document. It's a proof of residence, a list of income and expenses, a certified copy of your ID, 3 months bank statements, the applicant's latest payslip if applicable, certified copies of the birth certificate or certificates of the children, and proof of expenses. So a nice tip I always give my clients is to make a file, compartmentalize it in a monthly month-to-month basis, and put your slips away, because it doesn't matter if you go to court today or in 6 months' time. Eventually, you're going to need to see what your monthly expenses are with regards to yourself and your child, because your expenses are relevant as well. And just start making or compiling a file. Whenever you and your partner or the father or mother of your child are separated, and there's a maintenance obligation that is not inside of a relationship. I always tell clients to do this. Doesn't matter how friendly the parties are. You put your slips in or your receipts in a file, and you keep it. I am married very happily so, and I do this because you never know what's going to happen, and you would need those receipts, especially where there are children. And then you complete the relevant documentation. If you are not represented by an attorney, the clerk of court or the maintenance officer should be able to give you some direction as to how you would go about completing the document. And then you attend court. They give you a directive as to when you must return to court, and you make sure you're at every single court appearance. I always tell I always tell people that if it's impossible for you to get an attorney, go to the relevant legal aid board, go to the law clinics, because especially where an opponent is represented, you will prejudice yourself if you don't seek representation. You have a right to representation. But always follow the process. So this is my process. Before I complete the form, I make sure I've got the paperwork in order. It's that list I just gave. And then I complete the form, sign the form in front of the maintenance officer, because it needs to be signed in front of a commission of oaths, which the maintenance officer is, and then submit it and wait for your return date. The court usually takes responsibility for serving, but should you wish to expedite it, you can deliver it to the sheriff yourself or service upon the respondent. The respondent is usually then the other party.
That's amazing advice. So I
In
have heard a
short.
lot of people, and I've also read a lot of posts where people say that they won't even try to claim maintenance because their ex has lots of debt, and the ex says that they will get into more debt if they are sued for child maintenance. Do you have something that you can say to these parties that can put their minds at ease?
Yeah, well, look, the law says we must take into consideration expenses of a party, but it's not the most important thing. The most important thing that one must consider when thinking about maintenance as a whole is that the need for it is more important than the capability to pay
Yes.
it. Yeah, so it's easy for a person to sit back and fold their arms and say, no, I cannot afford to provide for my child any maintenance, or my spouse, because one can claim spousal maintenance as well. But the reality is the obligation is not extinguished. There is a law that says you are supposed to pay maintenance, right? So I take various factors into consideration when I answer such a question. The first is, does the person have assets? The person might not be able to be financially able to contribute a monthly amount. But in terms of the Maintenance Act, you can attach, or the court can attach, property to be sold for maintenance, to compensate for maintenance. Does the person have a pension fund? Because many a times I've seen it where the person would resign and have no income, but there's a R1 million pension fund. So does that make that person incapable of paying maintenance? No, it doesn't. So you have to take all of these factors into consideration. Is there debt owing to the respondent? If there is a debt owing to the respondent, the debt can be attached. So yeah, that's my advice on that. But there is never, and I tell it to my clients always, never a reason for someone not to pay maintenance. Don't have a job, make a plan. There is a child in need of maintenance or a spouse in need of maintenance. You've maintained them whilst you were living with the mother or father. Then you have the means to maintain. So all of us as parents on a monthly basis, we prioritize ourselves last. And there's always, I've never seen it in my life where there has been no prospect of maintenance, because there's always either a car or a pension fund or a TV or something that can be sold to provide maintenance. So there's no excuse. I've never seen it happen where someone can really not pay maintenance.
Definitely. I've heard about a case where the father didn't want to pay maintenance, and he was unemployed, but he lived in like a mansion with 4 bedrooms, and he was living alone. And then the court told him, listen, but you don't need to rent this mansion. You can get a smaller apartment, and then you will have more money to pay for your child's maintenance, which was really interesting to me.
Yeah, and it's usually a manner in which one party would use to spite the other, to delay a divorce, for instance. Look, there's no reason maintenance should even be a dispute. One should take the income, take the expenses, take the amount that the child costs monthly, and it should be fairly divided in terms of the income brackets of both parents and the capability. So, in terms of your means to maintain, the child's need to be maintained remains, no matter what. Even if a party dies, passes away, the need for maintenance does not go away. There should be provision for maintenance. If you have a child, maintain that child. It's simple. There's no room for negotiation with that. And I've had many people try to tell me, no, I can't maintain X, Y, or Z. But the fact of the matter is, there's always, if I go and I look in terms of Section 10, there's always a DSTV that can be cancelled and that amount of money can be contributed, or there's a Wi-Fi, or there's a motor vehicle that is exorbitantly expensive. Those things are not important. Maintenance will always come first. Always. It's one of the very few things, Daniélle, that can be attached in terms of pension. Usually one's pension is untouchable, but maintenance orders can cause your pension fund to be attached. It's one of the very few things that should give our listeners a very serious thing not to pay maintenance. So, that would always be my advice. I've also had clients on the spiteful end that said, no, I'm not going to maintain X, Y, Z. The fact is, I always say this, there is a need for maintenance, then you have an obligation to pay maintenance. Especially children that have recently turned 18, and where we see children going to university. The right or the need to maintenance does not distinguish or extinguish because you turn 18. If there's a need, then the parents have a responsibility
100%.
within reason.
Yes, 100%. Totally agree with that. So then lastly, I wanted to ask you, can you explain to our listeners what a garnishee order is and when you will get a garnishee order?
Well, a garnishee order would be an attachment of a portion of the salary of a person who is liable. I believe we're talking in terms of maintenance and not in general.
Yes, maintenance.
Okay. Yeah, it's when you get a order against someone to have the money for maintenance due and payable to yourself in favor of yourself or a minor child, paid directly to you by the employer of the respondent. So where the respondent would then in actual fact not be liable to pay maintenance directly to you, but it will be deducted from his or her salary.
Fantastic. Thank you for explaining
Yeah,
that.
it's much simpler. Yeah, it's much simpler, and it eliminates unnecessary friction.
Definitely, definitely. So, since this podcast is called Justice in Heels, I wanted to hear from you. Have you ever been in a situation where you were underestimated purely because you are female?
Yes, most definitely. I think you can, as a woman in law, also say the same. It's definitely a man's world, and a man's job that we do. It's not easy. But yeah, there's many incidents that I can refer to, but two in specific incidents stand out to me. The first was a client that just refused to deal with me because I'm a woman. He just insisted upon using the services of my partner, who doesn't even practice in the field where this person needed assistance. So he just basically blatantly refused to work with me because I'm a woman. That's the first instance. And the second instance is I received a call from an opponent of mine who's an attorney, used to act as a magistrate, which is the most concerning part. And he said to me, you know, I never represent a woman because they always think about things emotionally instead of, you know, factually. And he just blatantly refuses to represent women, and I was the women's attorney. So yeah, that's another. And I'm talking about someone who's a senior colleague who used to be a magistrate. So yeah, one can only think what bias was suffered there. So yeah, it happens, it's prevalent, but we are changing that one day at a time.
Definitely, I so agree with you. So, thank you so much for joining me, and thank you so much for educating our listeners on maintenance and parenting plans.
Thank you for having me. It's been a pleasure.
Can you tell us where we can reach you? Do you have social media? Are you on LinkedIn?
You can contact me on 011-753-1155. Alternatively, you can contact me on my cell phone on 083-224-2881. My email address is jo.venabu@global.co.za. That's jo.venabo@global.co.za. We are also available on Facebook, and you can like our page. Thank you.
Thank you for listening to this episode of the Justice in Heels podcast. If you like this episode, we would love for you to share it with your friends on social media and tag us. As this is a legal podcast, here is a quick disclaimer. The views expressed in this podcast are solely the views of the individuals involved and not those of the firms, brands, or anyone else that we are affiliated with. Till next time, goodbye.